I'm a mom. I want to be there for my kids. I want to put this all behind me.
No, but you can't just say I can commit all these crimes and then say I want to put it behind me.
I will
This is
not.
the thing. This isn't a simple, isolated mistake. You've got four. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people who through sobriety court who are not being honest with me. I will not do that. I'm sorry.
Well,
All right, let's take Shore credit here. Shore Financial Group versus Scott Ratliff. 21F1466 GC.
Your Honor, I
All
don't
right.
think I have plaintiff's attorneys back yet.
Sorry about this, Ms. Ratliff. Julie Teresa Gagne. 26306-741.
She is gonna be here in a moment. She got caught by a train and now she's on some road. I don't know, but she should be walking in.
People Against Summer, Lori Greathouse, 25F245336. Your name, ma'am?
Summer Greathouse.
Mr. Longton, your appearance? I need to read you both something that was handed me today. And I'm not trying to create any more problems here. For her and her ex-husband or estranged husband. But I need to read this to you because I'm not going to conceal anything, obviously. He just says to whom it may concern. Who am I hearing right now, Heather? Can you tell me?
I believe it's the jail background noise.
Okay, I'll keep my voice up nice and loud. I am writing to you as the sole legal property owner of the residence located at 30,001 Huron Meadows Drive, Rockwood, Michigan, 48173. I'm aware that the defendant, Summer Greathouse, is currently serving a jail sentence under your jurisdiction and has an upcoming court hearing. Please be formally advised of the following. 1, no consent for tether/ankle monitor location. I do not consent to my property being used as a designated residence, base station location, or monitoring site for any court-ordered electronic tether, scram device, GPS tracker, or house arrest equipment. 2, revocation of residency effective immediately. Summer Greathouse does not have permission to reside at, enter, or visit my property. Her residency privileges have been fully and permanently revoked. Formal eviction papers are currently being processed. Safety and security, that's number 3. For safety and privacy reasons, she will be barred from the premises immediately upon her release from the Wayne County Jail. 4, clarification of child custody, rebuke of fraudulent claims. I am aware of the defendant's history of perjury and manipulation before this court. Specifically during her prior bond violation hearing, I'm advised that she may attempt to claim her immediate release is necessary for childcare. The children are completely safe, stable, and cared for in my custody. Her claims of childcare hardship are entirely false. Because an alternative housing plan will be required for probation or tether compliance, I am notifying the court and the probation department in advance of her hearing so that her defense counsel, Mr. Longton, can arrange an alternative location such as a residential facility, shelter, or different address that does not involve my property. Thank you for your immediate attention to this matter and for ensuring this notice is placed directly in her official case file, respectively submitted, Harrison Steves. So with that,
I respond to that.
you can respond whatever you want.
I realize there's a lot of falsehoods in there.
Hang on a second, hang on. You asked for a hearing, you filed a motion. I don't quite understand this. Let's go quite forth on it. That the court opined on the record that defendant had violated her bond provisions by working in a restaurant that serves alcohol and not informing her probation officer about that employment. I had to go back and listen to the tape. I didn't say one word about that. What I did say is she wasn't truthful with me. What I did say is that when I asked if there was any material additions, corrections, or deletions, she should have been forthcoming. She should have been forthcoming with her probation officer. That's the only reason I scheduled this emergency motion for reconsideration of sentence, because that's just not true. I didn't say anything about bond conditions. I said she violated bond conditions in the past. She lied to me under oath in the first time she was drinking. She had 26 late SoberLink blows. She was positive for alcohol back in February 4 or 5 days in a row, 6, 7, 8, 9, and 10, I think it was. or February 8, 9, 10, and 11. And by the way, just to pile on here, she had to drive to court because somehow, some way, a car titled in her aunt's name remained in the parking lot for 2 days after she was sentenced. And by the way, I haven't checked it, but I believe she was still revoked. And this has been the pattern with your client. So you can correct whatever you want. I'm going to listen to you, and then we'll go from there. What do you want to correct?
She is a lawful resident.
That's fine. I'm not the divorce judge.
Well, what he's done. Trying to take custody away from her. He's grabbed the kids, he's changed the locks. She's a lawful resident of that house. That address is on her driver's license. She has the right to go there. Please enter that house.
I just read you into the record. What he said. I didn't say anything was truthful.
No, yeah, that's correct, John. You did not. But I wanted to make that clarification. I know my client is a deadline for me to address what you read in the record of that letter.
Okay, good enough. What else?
So what's happened is what I feared was going to happen. He's hired a new attorney. He's going to try to take custody away from her with an expiring order because she's in jail. I have no defense to that as long as she's incarcerated. And she's been the primary custodian of this children since birth. The biological father, the never married mother, has not been a primary caregiver, not been the co-custodian. He's seized on this. We bad custody. I think the children are going to be harmed if we continue to keep her incarcerated. I have no doubt.
Is that you, Mr. Are you Mr. Steves? Are you Mr. Steves?
Yes,
Okay, he's in the back. Go ahead.
I have no doubt that his children are being harmed by taking away.
I'm not, but I don't have anything to do with it.
I know you must, but you certainly have a jailhouse that you can care to by her own. That's what I'm having. She has learned her lesson. There's no doubt in my mind. She has learned her lesson all about honesty with his court and fucker.
Can't lie to the court.
Your Honor,
I will not go through a sobriety court with a defendant who's lying to me left and right. And I gotta tell you, I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
I doubt that. And you doubt that.
Your Honor, may I
It just
speak?
underscores how she has not taken this seriously. Listen,
Your-
I wanted to give you this hearing only because I wanted to clear up this record. I did
Yeah.
not say anything about bond conditions. That is
Yeah.
not a true statement, Mr. Longton. What I did say is she was not honest. I will let you speak for 10 seconds, ma'am, but you've got a lawyer representing you. This is a motion hearing. If you want to say something, you can, but go ahead.
Your Honor, when you asked me about the employment, I brought it up. I was unsure about bringing it up before that. I was desperate to just work for my kids. My kid's dad does travel a lot for work. I'm a mom. I wasn't sure what to say. You know, I wanted to bring it up. It wasn't something that was permanent. I want to complete this program. I want to be there for my kids. I enrolled myself in school. I've been going to counseling by myself. I understand that I made mistakes in the beginning, but I am more than committed and willing to complete this program. If you would please just consider it. I'm a mom. I want to be there for my kids. I want to put this all behind me.
No,
My-
but you can't just say I can commit all these crimes and then say I want to put it behind me.
I will
This is
not.
the thing. This isn't a simple isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people who through sobriety court who are not being honest with me. I will not do that. I'm sorry.
Will
The
not
motion
have
for
a
reconsideration of the sentence is denied. I wish you well. I hope everything works out for you and your family. I really do, Ms. Greathouse, but I'm not changing my mind. Thank you all. Have a good day.
And that's
But-
the final blow. The judge shuts down reconsideration completely because, in his view, Repeated dishonesty destroyed any path back into sobriety court. He even wishes her family well, but still refuses to change the sentence. That tells you everything about how serious credibility becomes once a judge feels manipulated. Do you think the judge was right, or did the defendant waste her final chance? Comment below, hit like, and subscribe for more real courtroom breakdowns.